Welcome to the Libertarian Counterpoint. I'm Richard Fields. On the program today, Damian Schiff, Pacific Legal Foundation Principal Attorney, and John Cameron, the author of Rewire and Rekill, both available on Amazon.
Thank you, Richard.
And I want to talk about wolves, or I think you want to talk about wolves, particularly gray wolves. I understand that they're endangered in California, but nowhere else.
Well, that's at least what the California Fish and Game Commission is saying in a pretty controversial decision that was finalized in December of last year. The Commission said that we're going to designate the gray wolf as an endangered species under the California Endangered Species Act, simply because a single wolf from Oregon happened to meander a few times across the California-Oregon border in 2011 and 2012.
What, border control was broken down?
Evidently so,
Okay.
certainly with respect to canines.
Because normally things want to leave California and go to Oregon, but this wolf hadn't read the newspapers and came down from Oregon to California.
No, he must have been just testing the waters. He has since actually gone back definitively, apparently, and settled down with a she-wolf in southern Oregon. But the larger point is that we have an agency that is dramatically expanding its power. Because now, of course, the Commission can say we can protect any species, no matter how tangential the relationship is between the species and the state, simply if it happens to land here or just travel here, as this one Oregon wolf did for a few months. The other point, though, is that ultimately there may very well be a population of wolves that establishes itself permanently in the state from Oregon. And the problem now with this listing is that it'll be very, very difficult to reasonably manage any type of population that does establish itself because the California Endangered Species Act is so draconian in its protections for species and at the same time in its burdens that it places on affected landowners. So anyone who has livestock, domestic animals, pets, what have you, in the range of these wolves that are coming into the state will have a very difficult time dealing with those threats.
In other words, if you have livestock and the wolf pack kills your cattle or your sheep or whatever, you're SOL. There's not a darn thing you can do about it.
There's no compensation to begin with, and there really isn't any effective legal method available to prevent an attack from the wolf.
You can't shoot him. You can't fence him off.
You can't even chase the wolf.
You can't chase the wolf.
Cannot even chase the wolf.
You can't yell at the wolf.
No, that would be harassment.
I see. Okay.
So,
now, is the wolf actually endangered if you look at the population globally or nationally?
No, absolutely not. First of all, the gray wolf itself actually spans Eurasia and North America. It's a very successful species altogether. But even if you just look at what the populations are doing in North America, they're all doing well, and that is one reason why the federal Fish and Wildlife Service a few years ago has proposed to remove the wolf entirely from the Federal Endangered Species Act, precisely because it's no longer on the brink of extinction. It's doing well.
What's the legal remedy that PLF would be interested in?
The remedy would be to sue the Commission, the Fish and Game Commission, on the grounds that it had no authority to protect the gray wolf, not just because it's not endangered, but also because this particular type of wolf has no real connection to the state. And the Commission's authority is limited to those species that are already here and have a strong ecological history here in the state.
Was there ever a gray wolf population in California?
Certainly not the type of gray wolf that's now expected to come into the state. Those gray wolves were introduced into the Idaho-Oregon area in the 1990s from a population of wolves in British Columbia. And those wolves north of the border are much different from the wolves that would have been found historically here in California.
In what respect? Biologically? Or?
Yes, physically larger and hungrier and able to take down larger prey, which means not only difficult things for ranchers here in California, but it also means that you have native prey populations that probably will be overconsumed because you now have a non-natural, non-native predator.
So what we're really doing, or what the Fish and Game is really doing, is introducing an invasive species.
Absolutely, under the guise of restoring supposedly a native population.
Question.
Which never existed.
Correct.
So if you took the logic or lack of logic they're using to an absurd level, I live on the American River, not on it, but right next to it, and birders are out there all the time. And if a species shows up, a type of bird that's rare, that's like lost its way from Colorado or is somehow 1,000 miles away from its normal flight path, let's say it got confused somehow, and lands here, couldn't they say, oh, that bird's here and we've got to protect that bird?
I think that's a very natural consequence of what the commission has done.
Or a species of plant.
The same thing.
Because they migrate and birds drop the seeds out of their bodies and they grow places.
Absolutely.
So they really could use this as an excuse to do anything they want.
Now, the practical repercussion of an endangered species being found in a given locale is to essentially shut down all commercial business opportunities on that land.
Effectively,
right?
yeah, especially when you have a species like the wolf where it's an active threat. It's not just simply you can't build something around its den or otherwise disturb its normal processes. It's that it actively is causing harm to the business, in this case, typically a livestock business, ranching.
So it's, not only does it cause harm to established farms and ranches, but it also ranges quite widely, I would guess.
Indeed,
So the habitat,
hundreds of miles.
the habitat for one wolf or one wolf pack would be many square miles, probably.
Indeed, no. I mean, in fact, a wolf can disperse hundreds of miles from its main territory. So we may very well see wolves here. I mean, we already have wolves in Sacramento because of the politicians, but we may very well see actual wolves here.
Well, there are wolves here that people keep as pets. I'm sure it's illegal.
Yes.
But, so then somebody lets their wolf loose, and it's a wolf. Doesn't matter if it's somebody's pet, and it's part of that species, it would be protected. So if
Yes,
it was
it would.
mauling your child,
Well, thankfully,
mauling your child would be.
if it were mauling your other pet, for example, you would probably be out of luck.
So the wolf has priority over
Fido.
Rover.
Yeah.
Okay.
So it's not going to happen in my house. Goes after my beagle.
Do you anticipate legal action anytime soon?
Absolutely. No, I think the foundation will be filing a lawsuit in short order on behalf of these affected interest property owners to bring a little bit of balance back into how the Fish and Game Commission administers the law.
Now, that's a California issue. And
Yes,
of course, California is in the vanguard when it comes to silly regulations and laws, but certainly not far behind is the U.S. Army Corps of Engineers and the Environmental Protection Agency, affectionately known as EPA. I understand that there's a Supreme Court case that is seeking to check some of the overreach by the Army Corps of Engineers.
Yes, a case that my colleague Reed Hopper at Pacific Legal Foundation is taking the lead on. And the issue is a follow-up, a close follow-up to a case that the foundation had a few years ago in the Supreme Court called Sackett versus EPA. In that case, the question was when the federal EPA issues an order to a landowner saying, you're violating the law, you're filling in wetlands without a permit, stop your work immediately, and if you don't, ruinous fines will be imposed upon you.
Ruinous meaning?
$37,500 per day.
Which can be doubled.
Absolutely.
Yeah.
In response to that kind of order, can a property owner take the agency to court and say this is legally bogus? And the Supreme Court in that case said, yes, it can. Here, we have a similar issue. We have the Army Corps of Engineers, not EPA, but the Army Corps, telling a landowner, we have control over your property because of the Clean Water Act. Therefore, if you want to do anything productive with your property, you must first get our okay. But, by the way, we're very unlikely to give you our okay, at least not what you think is going to be worthwhile for your business. Now the question is that kind of a statement or that kind of a decision, can that also be challenged immediately in court? Or does the landowner not have any effective way of fighting back at that point? So that's the issue now that the Supreme Court will address.
For a peat bog?
Yes. Our clients, if it's a family-owned peat mining business. Now, peat is a type of wetland soil that is especially helpful for things like golf greens, putting greens. And our clients, their peat operation depends upon access to these peat bogs. And they have an option to purchase land that contains a lot of this peat. But the Army Corps said, we're not going to allow you to mine this area because these are wetlands that are controlled under the Federal Clean Water Act, and frankly, we're probably not going to give you a permit anyway.
So isn't peat a renewable resource? It grows slowly, albeit slowly.
But it is a
back.
natural, exactly.
Yeah. So it can be harvested just if it was a forest.
Peat is the precursor to coal, is it not?
You know,
It's decaying plant material.
Well,
I believe, right?
It must be. Yes, I'm afraid
okay.
you've caught me there, but I think it would take millions of years, probably.
Right, exactly.
Right,
yeah.
but no, you are right. Yeah.
So about as long as it would take for the Army Corps of Engineers to approve something like
Precisely.
By the time this permit is
the peat
granted,
will be coal, and it will
be
no
long, and it
longer
won't matter.
it'll be
qualify,
anthracite.
But
as a wetland, because it'll be anthracite.
Yeah.
so the Supreme Court will
Now, the Supreme Court has already accepted this.
exactly, and so it will probably be argued in March or April, and we'll have a decision by the end of June.
Now, this was a case that was won at the circuit court level. Is that correct?
That's correct. Yes, the Eighth Circuit Court of Appeals agreed with us and with our client and said that, yes, we have the right to sue the Army Corps immediately.
And there is a conflicting case elsewhere.
There are.
Cat recycling or something like that?
Yes. There's a case from the Fifth Circuit Court of Appeals out of Texas and one from the Ninth Circuit Court of Appeals, the case originally coming out of Alaska, that went the other way, saying that a landowner does not have the right to sue even in the face of this kind of determination.
Now, are those also on appeal to the Supreme Court?
No, those cases, well, one of them actually is pending in the Supreme Court from the Fifth Circuit, another case that PLF is involved in. And that case...
But not accepted at this point.
...will probably be put in abeyance pending how the Hawks case turns out.
Okay, so they'll use that to set the precedent for Kent, is that what you're saying?
Yeah, I think that's my expectation.
Okay, how do you anticipate this case, the arguments and the results coming about in Hawks?
Well, the key is to show that when the Army Corps, or for that matter, any federal agency, tells someone, we have authority to dictate what you can and cannot do on your property, that has significant legal and practical consequences. That's really the key. Traditionally, the courts don't want to get involved in cases if they feel like it's an academic dispute. You have to show that something meaningful is going on.
Like your livelihood,
Precisely.
or your property, or your fortune.
Exactly.
In this case. And
so the question is, when an agency makes a statement like that and means it and backs it up with a formal administrative process, isn't that enough then to allow an aggrieved property owner to say, I disagree with that determination, I want a federal court to review it?
Okay, so the Army Corps of Engineers has said in so many words, we're not going to give you a permit.
That's right.
But they're arguing in court that they have not made a final determination?
That's right. Technically, they haven't. The only thing that they have formally done is to say, we have jurisdiction over your property. And sort of sub rosa, they've said, well, by the way, you're never really going to get a permit, at least not on the terms that you want.
Now, peat is, by definition, a product that's found only in wetlands.
Yes. Now, the critical distinction here is that not every wetland is a federal wetland.
What's the distinction?
That, unfortunately, is not clear, and that's sort of the...
So the ones they want are federal wetlands, but the ones they don't want are not?
I've never known a wetland that the feds did not want, but...
You know, we used to call
what I'm getting at is, would it not be tantamount to shutting down the peat industry if this goes the wrong way?
Well, it would... I would say for people who are less politically connected than our or more politically connected than our clients, no. But for those who...
So in other words, the peat, being able to harvest peat will depend on corruption.
It will depend upon whom you know in the agency.
In other words, corruption.
Can I ask a kind of a theoretical question about this, Damien? So basically, the way I understand it, the Corps of Engineers is saying that we have the right to tell you what to do with your property because it's a wetland. And we can enforce a fine. I imagine they could even arrest people or have people arrested for failing.
Well, there's certainly criminal sanctions under the Clean Water Act.
So criminal as well as civil.
Mm-hmm.
So they can, in essence, put people in jail.
Yes.
But instead of being able to be heard by a jury of their peers, as they would in a crime of, let's say, somebody committed a robbery or they stole a wallet or defrauded you or anything else, they in essence have to appeal not to a jury of their peers, but a self-appointed bureaucrat to rule whether they're criminals or not. Doesn't that patently violate the Constitution?
That's certainly our argument, and that's one reason among many why we think a landowner in that circumstance should have more of an opportunity for judicial review, and that the perfunctory rubber stamping of some agency official is inadequate.
So the agency can, in essence, write its own set of rules and then criminally enforce those rules under the current law, and until Sackett, people couldn't appeal to anybody but the agency who set the rule and told them they were a criminal, in essence.
Yeah, well, it is true that if they wish to bring criminal charges, there does have to be a jury process. But the reality is that the agencies don't even need to bother with threatening criminal sanctions because the civil sanctions
are so ruinous
anyway, and there's no right to a jury trial anyway for that type of a lawsuit.
So civil, in essence, basically say, we want you to stop doing what you're doing, even though it's on your own land, because we've determined that what you're doing in our eyes is wrong, and we're going to sue you into bankruptcy, and you pretty much have to pay us, and the only place you can appeal is us.
That's their MO, and it's been very effective for them over the last several decades.
It's time you guys put a stop to it.
Well, we certainly hope to.
I'm guessing that part of this is because people just don't have the basic education in order to understand their rights under the Constitution, the basic education to be good citizens and be responsible citizens and so forth. And education, of course, is largely controlled by the public sector. The state of Montana is moving in a direction to make it less so. They have a new scholarship tax credit that offers tax credits for private donations to scholarship organizations. But there's a glitch.
The glitch, unfortunately, is the Montana Department of Revenue and its interpretation of the Montana Constitution. So to give a little background, I mean, there has been an effort for a long time to bring more choice into educational decision-making.
For bad versus good?
Yeah, exactly. And Montana, to its credit, wants to enable parents to select the schools that they think are best for their children. And so it created this program whereby an individual can donate to a private organization that runs a scholarship program and can get a tax credit for that donation. And then, subject to a strict series of controls and protocols, these private party scholarship organizations can then offer scholarships to qualifying Montana students who can then take that money and go to any accredited school, whether it's a religious or a secular school, to be used for secular education. The Department of Revenue, though, says that that program violates the state constitution's separation of church and state, even though the money that's at issue never actually gets into government hands. As I say, it's a donation from one private party to another private party, then to the students.
To pay for private education.
Correct.
So even the Department of Education or the state-run schools isn't involved in this process at all.
If anything, they might even get a net benefit because of the
Free money, because they're getting paid.
They're getting paid anyway, even though the students aren't coming to their schools. So
Well, hold on, they're paid per student that shows up at their school. At least in California, they are.
Right. Well, that's a point I'm not actually too clear on with Montana, but the underlying legal issue is the fact that the Montana Constitution has what's called a Blaine Amendment. These were amendments that were passed in the late 19th century that were essentially anti-Catholic and animus. And the idea was that all students should go to public state-run schools, and there was a strong desire to discourage anyone from going to parochial schools. And unfortunately, it's that tradition that the Department of Revenue in Montana has interpreted as forbidding this scholarship program, and that's what we're fighting against.
And what's the legal process for stymieing the efforts of the Montana Department of Revenue?
It began with a complaint that we filed earlier this month and in federal court in Montana, and we're asking the court basically to overturn the Department of Revenue's interpretation of this new law and to say that the tax credit and scholarship should be available to all Montana citizens.
Well, what was the intent of the legislature when they passed the law?
The intent was precisely as we are advocating in the lawsuit. The intent was just to give Montana students and parents more options.
So a bureaucracy is essentially overruling the intent of the legislature as far as this law is concerned.
In fact, we know that for a fact because subsequent to the enactment of the law and the agency's promulgation of this interpretation, the Montana legislature took a straw poll on the question, does this agency interpretation reflect what we intended in our statute? And the straw poll overwhelmingly said, no, this is not what we intended.
So this is essentially a bureaucracy gone wild.
Again, yes.
Shocked by that.
Amazing, yeah. The Sixth U.S. Circuit Court of Appeals has issued a nationwide stay of the Obama administration's drastic new rule that gives an open-ended definition of the waters of the United States. How does the waters of the United States, how has it been redefined by EPA?
Both EPA and the Army Corps have, over the last 20, 30 years, been trying to expand dramatically their authority under the Clean Water Act. If you look at the text of the Act itself, it says, if you want to do something in navigable waters, you need a permit. They have interpreted that phrase, navigable waters, well beyond those waters where you can actually float a boat, to include essentially almost any tributary, any stream or creek, or any wetland in the nation. And the new Waters of the United States rule that was issued in June of last year essentially says, if it's wet, we've got authority.
I saw a map put out by the Farm Bureau of the state of California, which was showing in one color, red, what would be considered waters of the United States. And essentially the entire state, including most of the Mojave Desert, was red.
Exactly, because the remarkable thing is, as the agencies would believe it, you can have a water of the United States even if it's only wet a few days a year.
And the effect of this new rule is essentially that Army Corps of Engineers and or the EPA have the final say on how any land in the country can be used?
It is. It's essentially a federal land use statute based upon how the agencies have interpreted it.
And the ramifications of that from a practical standpoint would be that whenever, I mean, well, maybe not obviously, you would think that they're not going to get involved in every land use decision that takes place, but if they want to, they can.
And because of that fact, they have tremendous leverage. Tremendous leverage.
So they can say, okay, we'll give you a permit or we won't make problems for you if you do it our way.
Exactly.
And what would their way be? It could be essentially anything.
Significant mitigation, cash payments to third-party environmental organizations for furthering...
Give us part of your land in order to use the other part.
Exactly, yes.
So I thought that government agencies weren't allowed to charge people fees or take money or take land from them unless it was directly related to what the people wanted to do. In other words, if you wanted to improve 10 acres, they couldn't say, okay, because you want to improve this 10 acres, you have to buy 1,000 acres here and give it to this organization. But that's in essence what this is allowing them to do, or what they're doing.
Well,
they're currently doing this.
Part of it is that they'll say, you're affecting, your project is having an impact on 10 very high quality wetlands, and that's a factual assertion that is hard to contradict, because courts will defer to agencies on things like that. And they'll say, because these are high quality wetlands, you then need to mitigate by purchasing or restoring 100 medium quality wetlands.
Now,
so your 10 acres are really good swamp. So since you want to develop this really good swamp, we want you to turn 100 acres into medium good swamp.
Right.
Okay.
Now,
you got to simplify things.
isn't this in direct contravention to the PLF Rapanos decision from 2006?
Yes. Well, and that's another case that my colleague Reed Hopper at the Foundation won, challenging in that case the Fed's assertion of jurisdiction over a few wet spots in a Michigan cornfield that our client owned and wanted to develop, that was located dozens of miles from the nearest navigable water. And the Supreme Court in that case said, that's going too far. Now the problem is that the court in that case could not agree on the reason for why that went too far. And so because of that failure to agree, the agencies have taken advantage of that confusion, and why we have the current new rule.
So they're taking, it was a 4-4-1 decision, as I remember.
That's
with,
right, yes.
Kennedy issuing the one saying,
in the middle.
It's okay. This is wrong, but we have to look at it on a case-by-case basis, basically.
And precisely because his opinion was so obscure, it has given the agencies a lot of wiggle room.
That's the show. We'll see you again next week, same time, same place, on the Libertarian Counterpoint, on YouTube, on the web at www.accesssacramento.org, in Sacramento on Channel 17 at 8 p.m. Thursday, noon Friday, 4 a.m. Saturday, and cable channels all over the place. Check your local listings. Thank you very much for being part of the show. We'll see you again next week.
Thank you, Richard. Really enjoyed it.